Hello, good evening, everyone. Welcome. This is the first international conference, the future of um, the stu. This is an honor to have you all here, and I would like to thank for your presence. Thank you for all the guests here. And this event is a partnership of CR Connection, EMI, Edward Mediation Academy, and Impact Hub Curitiba. And we never know an event alone. We would like to thank for the supporters, OAB Paraná, OAB Santa Catarina, Rio Grande do Sul, PUC Paraná, the groups of studies of mediation in PUC, this Institute of Lawyers in Paraná, BDCons, meetings of negotiation, Institute of Práticas Colaborativas, Instituto da COR, Via Concórdia, MMG Advogados, GST LLP Advogados, Grupo Starter, without whom this event would not be possible. As a director of CSR Connection, I would like to talk about our mission. Here at CR Connection, we look for connections with purpose and success. Our mission tonight is to inspire the construction of sustainable relationships for the professionals of the area of resolution of conflicts, connecting causes based on purposes, people, leadership, and global leadership. We want to have a market that is sustainable, more productive, and with more satisfaction. 50% of the workforce in the world will have to adapt to a new reality. So they have to have decision making and complex problems, self-management, flexibility, critical thinking and innovation, creativity, leadership and collaboration, and connectivity in a global world. So tonight we are going to investigate what is for professionals of law for the future with the participation of international names, and they are here to talk about lessons learned. Here we are proposing an open dialogue to cause a disruption about our reality. Now I'd like to introduce to you Dr. Flavio Pancieri, who's a director of CR Connections, and he's going to talk about the future of law practice, and then we're going to talk about the moderators. Enjoy your event. It was made for you and with you. Thank you very much. Thank you, Professor Luciana Dremel Dias, the big person behind all the project. She is here connecting people and trying to solve conflicts. This is why we have been talking for 6 months to come here and to find a place for dialogue, talking about actors for conflict resolution with mediation in Brazil and outside of Brazil. It is a pleasure to be a part of this journey, and this is an event that is a success, but especially because we have this logic of institutional connections, and we are going on a solid path because we are being able to put partners together for this initial meeting, but especially the public who's here already understanding this new moment of law practice in Brazil with national and international experience we are going to share today, and that's going to be very positive for everybody who's here today, I'm sure. I have to say Also, I have to talk about the importance of this initial project because this conference is related to a second moment, and that is the project we are going to show to you, and it is about conflict resolution. This is a second step for CR connection, and it's going to be available for the whole national community. And I am sure it's going to be an element for the formation and connection for people because we want conflicts to be solved in a way that is non-judicial, and want that to be something important for Brazil, especially considering the Brazilian economy is one of the most promising all over the world. The International Monetary Fund recently said that, and they said our economy will not suffer the crisis that Europe and other countries in the world will suffer soon. With that, I register my satisfaction participating in this project, and I pass the word so that we can start the first panel to Dr. Gabriela Assmar, who is also one of the heads before this project together with Professor Luciana, and so that this ideal could come true with lawyers who want to have a different model for solving conflicts in our country. Professor Gabriela has a master's degree in the University of New York. She has practiced in the US and in Argentina. She is an international mediation experienced leader also in the United States, and she's the co-founder of the Commission for Mediation in Rio de Janeiro, and she has a fundamental role at the CR Connection as being part of the idealization of this project. Also, I'd like to mention Professor Fernanda Levy, who is also a mediator. She's certified by ADR in London and MAA. She is a partner in the Core Institute, and she's a mediator for complex cases. She works with FGV in São Paulo. She got a prize in 2019 as the best mediator, and that happened 2 years in a row. And we are sure that she's going to bring interesting reflections we are going to share today. Also, she's one of the instructors for our CR connection, and the idea is to put ideals and minds together with the purpose that is to create a space for solving conflicts in a different way in our country, with more agility, more reliable, and especially for the world of business, saving costs. With that, I finish and I pass the floor to Professor Gabriela Asmar so that she can conduct the first panel. Professor Gabriela,
Estamos na
please.
transição. Quem quiser fechar a câmera pode fechar agora.
If you want to close your cameras down, this is the transition.
Gabi, vamos
Are you
lá.
ready?
Quem mais vai fechar a câmera? Marcos? Não. Vamos entrar em 5,
Flavio, close the
4,
camera. Marcos,
3,
no.
2,
5,
1.
4, 3, 2, 1. Good evening, everyone. We have the opportunity here to share some moments with some of the most brilliant minds I had the privilege to get to know in my life. And if you know me, you know I'm not only talking from my head, but I'm also talking from my heart. So I'm not going to read the resume of these wonderful people, but I will talk about what I know and what I think comes from the heart. And maybe it will touch the heart of the people who are listening to us. So I have to start with Bruce, who is our keynote speaker. He is the person who is going to introduce this subject for us. Bruce is the pillar of knowledge that is so broad that's starting to get more accessible, not only for the group of privileged people who get to know him, but also all over the world. After he was one of the, well, considering he was one of the pioneers of mediation in entrepreneurship in the US, it's very important for us to understand that in the US, a lot of the market of the mediation market was created in a context of a different judicial system. And some people, after being judges, became these facilitators because they were already judges who knew how to close deals. Bruce has always been a lawyer. He has always been known as a brilliant lawyer, and he decided to become a professional who would facilitate the negotiation of clients and lawyers, and he has been doing that wonderfully. The company he founded is now together with James, who is the provider of mediations for all over the world for entrepreneurships, and together with his wife Susan, who's also a fantastic and brilliant person. Together, they are creating a platform for knowledge, for the mediation, very high level, focusing on this type of mediation, and he inspire not only us but people all over the world. And this is something that is going to be here forever. If you want to learn about entrepreneurship mediation, you have to listen to Bruce. Now I'm going to talk about José Gabriel Assis de Almeida. He has a million titles in Brazil, in Paris, all over the world. He's an excellent professor, and I can say that with happiness, he always inspired me in my career that touches my heart, really. He is a changing point in my life, and I know in many other people's lives. José Gabriel, apart from being my professor, well, I was his client because I was able to hire him because I knew that my department had a lot of negotiation going on. So I needed to have a lawyer like José Gabriel, who is a person who facilitates businesses. He looks at the law as a tool, and he knows what is important for the client, and he tries to find a legal, fair, and simple way to make law being good for the client. And I am absolute, and I'm a total fan of José Gabriel. That's what I wanted to say. And finally, Pércio de Souza, who's a person with a lot of history in Brazil. He has a history of negotiation. After a long career in the financial market, started in 2002, and in this expertise of acquisitions and mergers, he had the opportunity to work with big cons- um, situations in Brazil with the petrochemical areas, so many things. I know everything is in your CV. I'm not going to tell it all. But what matters here is Percio has a very valuable uh, time, and we are very happy to have him here to talk about what most of the lawyers want to know but don't know how to ask. So Percy is an engineer, but he's very good with strategies of negotiations, and he needs the lawyers at the table, and he needs to deal as a negotiator with the lawyers who are on the other side. So he's the best person to to give us a reference of what is important for the negotiation when we are lawyers in a situation when you have a collaboration, but not completely. We only had this if everybody is there, and I have to see my limit as a negotiation. So, if you want to complement, it's a lot of information. And I would like to pass for the first question about our model for transformation and economic growth for lawyers. Rose will be the keynote speaker, and after I will ask questions. I have some questions here, and we know that the public may have some questions, and we are going to have an administration of final words. Bruce, please.
Thank you, Gabriela, for the kind words and introduction. I'll do my best to live up to that. Welcome, everyone, or should I say, more importantly, thank you for welcoming me this evening to this esteemed program. I look forward to the opportunity to share my thoughts and experience with you on the new business advocacy model. I will begin tonight with an apology. My apology is that I apologize I cannot address you in your native Portuguese. I wish I could. But the good news is that the language of conflict and therefore the language of dispute resolution is largely universal. I've heard the word connection tonight several times. What allows us to connect as individuals, and more importantly, what comes apart when those connections no longer work, are things that we're going to be talking about. And those issues transcend language, they transcend culture, and they transcend boundaries. Maya Angelou is a famous African-American poet, and she very concisely says in one of her poems, "We are more alike than we are not." And in that simple phrase, I think illustrates what we all have to talk about this evening, those things that bring us together, those things we have in common, and those lessons we can learn from each other. I'm going to talk a little bit about the trajectory of dispute resolution in the United States and the new business advocacy model as it's being described tonight. But I think it's important to know where we've come from before we see where we're going. And almost 2 centuries ago in the United States, one of our most famous United States presidents, Abraham Lincoln, gave a quote that is very famous to many in the United States. I noticed this evening, Luciana even had it printed on the wall behind her. It's that famous, but I want to read it to everyone. Abraham Lincoln said in 1850, "Discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. And as a peacemaker, the lawyer has a superior opportunity of being a good man or woman, and there will still be business enough for everyone." And yet, for the last 150 years or more in our culture in the United States, litigation reigned supreme. Lawyers were taught beginning in law school that litigation was the only way to resolve conflict. Young lawyers in law firms were taught that being a good litigator was to be valued above all else. And clients selected lawyers based on one thing, their litigation skills. And the only head nod, if you will, to there being an alternative to that litigation process was an occasional reference to arbitration, be it a law school class or maybe a contract clause. But for the most part, litigation was the way we resolved conflicts, and this only way we resolved conflicts in the United States peacefully for hundreds of years. And this was the legal paradigm that I graduated into almost 42 years ago. And I began work in this litigation law firm in San Francisco, began representing clients, and very quickly realized that my experiences as a young lawyer, and more particularly what I was being taught, didn't comport, didn't match up with my life experiences in problem solving or with my formal education in psychology. Our ability in the law to address the needs and interests of the parties fell victim to rules of civil procedure and the way we were taught to deal with these problems under the law. And in fact, rather than bringing people together, what it did was it polarized people and it jeopardized relationships, and it created huge expense and time involved in that litigation process. And so I really began to think about that in those early days and questioning pretty quickly my role as a young litigator. This problem-solving role that we have as lawyers that Abraham Lincoln referenced really fell victim to what we were being taught formally and how to approach conflict resolution as young lawyers. And some of my earliest examples and memories of representing clients in the litigation process were less than satisfactory, certainly for my clients, and therefore for me as well. I would take clients to the courthouse. They would sit out in the hallway on a hard wooden bench while I would go talk to the judge in private and try and decide my client's fate, in essence, often coming out in the hallway to tell them what the judge had suggested they needed to do with this conflict in the rest of their life. And I could see on their faces, etched in some degree of pain at a minimum, the chance they had not to be heard, the chance that they missed in not participating in that process. And it was a much less than satisfactory opportunity. And so recognizing pretty quickly this incongruity between what I early on came to understand as the basis of human conflict and the things that gave us a key to trying to unlock that conflict and the incongruity with our civil justice system, I began to experiment. I started pulling people together in the same room. I sat them across the table from each other and asked them in front of somebody else, how did this person's actions impact you in your life? And sometimes there were discussions about facts and law, but there were often discussions about pain and emotions and things that people experienced as real people as a result of those human interactions and those failed contacts. And over time, I realized that it wasn't about me, it was about this process. And this process had a certain magic to it that, although messy at times, more often than not, it was successful in helping people find compromise and find creative solutions to their problems. So being the steward of this process time and again, seeing it succeed more often than not, I began to see its tremendous potential. And that early on sparked me 30 some years ago in my legal career to take the bold step away from my law firm. And much to the dismay of my parents and my friends who wondered why anybody would give up a good job as a partner in a law firm to try something completely new and for many unheard of, I began one of the first mediation practices in the United States, where we made the decision to take lessons that were historically used only in community mediation and family law mediation and apply them to civil litigation, some of the biggest disputes that businesses and individuals can imagine finding their way into the court system. And at the time, I was a 30-something-year-old lawyer. I was not a bastion of success in the legal profession. I was not an esteemed retired judge. I had no venture capital backing. All I had was an idea and a sense that it made so much sense to bring people together and work through problems in this fashion that it had to find its rightful place in our justice system. That was over 30 years ago. And if you fast forward, and this is not my success, this is the success of an industry, but if you fast forward 30 plus years, we've changed a litigation culture that was over 250 years in the making. We now have courts that require mediation before parties can gain access to scarce judicial resources. We teach mediation skills in law school. We tell young law students that if you want to be a litigator, your chance of being an advocate for your client in a courtroom, maybe you'll get there once in the first 5 years of your practice. But in contrast, if you want to be a mediation advocate, you can represent your client perhaps in the first 5 days of your practice. And in that fashion, try and entice them toward the benefits of mediation. And we grew a company, as Gabriela has suggested, is the largest in the United States. Over 400 panelists, mediators, and arbitrators from 26 of our different states. And last year, we mediated over 15,000 cases, some of the biggest business disputes, environmental claims, construction projects, banking failures, insurance claims, employment issues, personal injury claims, and wrongful death suits in the United States. And that number keeps growing year over year. And we're not alone. We've developed a cottage industry of mediation companies that emulate our success. We've found hundreds of lawyers and retired judges going into the mediation profession, offering their services to try and help conciliate and facilitate conversations to keep people out of the court system. And just last year, there was an article in a major law review from a law school in Oklahoma in the United States, having done a survey of civil cases and those that went to trial. And it was an incredibly insightful result that they found in the last 10 years, we're now down to less than 1% of those cases, civil cases filed in our federal court system actually make it to trial, less than 1%. And as a consequence of reducing that backlog that when I was a young lawyer could be as much as 4 or 5 or 6 years to get a matter to trial, it's now down to where judges are ready, willing, and able to entertain trials because at least before the pandemic, there was plenty of judicial opportunity to address disputes in the court system. And so we've had profound changes and impact on our system of justice because whenever you can increase the availability of the court system, and indeed there are those cases that still need to be addressed through the court system, you're increasing access to justice. And conversely, when you deny people access to justice, you deny them justice. And so mediation has had a profound impact as well. We have had an opportunity now to sort of look ahead and think about training the next sort of generation of mediators, but at the same time, looking to train the next group of important stakeholders. And that includes most of you, the lawyers, because this mediation process does not succeed without the buy-in of counsel. And that means not just the buy-in of counsel, but it means developing skills and nuanced experience that will help you deliver winning results for your clients in this process. And along the way, we try and educate and break down misunderstanding about the process, fears about how this process impacts your law practice and your finances and everything. This begins in law school. And so while I mediate every day and have for the better part of 35 years, I find time to lecture in law school classes, helping young lawyers begin to appreciate the importance of mediation as a distinct and different tool of advocacy, not to the exclusion of litigation, but as a complement to their litigation skills. And so we teach courses on mediation advocacy. I write blogs on writing an effective mediation brief. I go into law firms, either virtually or in person, and offer seminars on mediation advocacy for young lawyers. So that, as some of my partners in the mediation world have said, many young advocates will spend weeks or months preparing for a trial or an arbitration. Yet all they think they need to prepare adequately for mediation is a good night's sleep. And that's obviously missing the whole opportunity. And we can get into it in more detail in answering questions, but the opportunity to sit across the table in dispute from the person that has done you wrong, to capture their attention, to deliver a heartfelt message in your own voice is an opportunity that does not exist in the litigation environment in the United States, yet it does in mediation. And it's one of the things that we promote. So I'm going to draw my comments sort of to a conclusion because there's many more people that have information to share with you tonight, and I'll certainly address questions as they come. But clearly the future of lawyering includes mediation and mediation advocates. We just saw an article this week about young lawyers who are looking for better ways to be advocates in the profession, to make a difference using their legal background and resisting the sort of formal litigation education that really earmarked our profession in the past. And it allows us the opportunity to return to the roots of our profession, to look for those ways to perfect compromise, to look for creative solutions, and really provide the sort of valuable interest-based solutions that President Abraham Lincoln was referring to in his quote almost 200 years ago. And the message for young lawyers, and I stand here as an example, there is a business opportunity in addition. You can do well by doing good. And there are hundreds, if not thousands, of mediators sort of living that principle in the United States. And I look forward to the questions. I look forward to the conversation and interaction this evening. But thank you so much for your generous gift of time and the opportunity to address you. So thank you. Back to you, Gabriela.
Ok. Esse probleminha do microfone, a gente vai
Okay.
melhorar para sempre.
I have a tiny problem with my microphone. Apologize about that. Bruce, you spoke a lot about the development of the market of mediation in the US. Your history is totally connected with this process. You lived this genesis of the market of mediation in the US. So the question here is more about an economic model that comes from these recent decades, but what is going on in the future? What's going to happen in the future? How can we look at this recent past and imagine what we have ahead of us in a future that's close to us? And I'm asking you about the US, but I will leave a question here for José Gabriel, because José Gabriel has a lot of experience in many countries as a mediator, as a lawyer. And José Gabriel, in the same line of what I asked Bruce, how do you see this market that is being transformed is in the business law practice, past and future? This is my question for both of you. Thank you very much. Thank you, Gabriela. I'd like to thank everybody who organized it and make this meeting possible. Thank you very much. The nice invitation for being here. And your generous, although exaggerated, words about me. So, your question is very interesting and intriguing, and I'll try to be objective. I would like to talk about three pillars. First is to know what we are talking about. When we are talking about this business or this mediation, the law practice of mediation, and that there is a research. I don't know exactly how precise it is. They say a margin of errors. Brazil has more than 1 million lawyers, 60% of them work by themselves, 27% work in offices, 6% work in public institutions, and 4% in the juridic department of enterprises. 42% of the lawyers, they are fundamentally working with family, 38% in the working law area. So 80% of the activities is families and in the law business. Entrepreneurial is only 14%. the total is more than 100 because you could have more than one answer. So if we put family and heritages and loss, etc., we have 104%. And then we have criminal and then entrepreneurial and contracts in the very end. So it would be interesting to have these numbers. It's also interesting to talk about the average income of these lawyers. The average was 5,800 reals. 44% would have up to 2,500%, 11% who had more than 10,000. So there is a data that is sad for the gender equity. Men gain 25% more than women. And the majority of the people is very satisfied with their profession. The average men and women is 7.8. They say they're very satisfied. And when they're separated by gender, women are 7.1 and men 7.9%. So these people are the lawyers for mediation, for these 14% in the entrepreneurial area, I would say. One question I asked myself a long time ago, what is important for being a mediator? There is not a place for everybody to be a mediator. And I do not consider myself a mediator. I think I'm very bad at this. I've been working with so many things, and to be a mediator, you have to have a special kind of head. Maybe I don't have it. So I think it is important to be a lawyer in this area and to know how to advocate, as Bruce said. It is necessary to get prepared to a mediation in the same way you get prepared for a meeting or for a trial. There is no way you can say you just have to sleep well before your mediation work. No way, yeah. So we have to bring this perspective to this market of mediation. I think mediation is super important, and here comes my second and third points. I think the profession of being a lawyer is changing. Three things are relevant. First, everything that's possible to be automated will be. When I was a trainee, I had to make a Xerox copy of a process, you see. So we had to do many things manually. And the trainee had to be good, to be quickly going to the forum to take the Xerox copy, you know. Nowadays, everything is automated. Even the judicial sentences now in France, there is a program being tested for having decisions to having decisions automated. Can you imagine that? So you put the data and the program will propose a project for an agreement and the judge will see if that's working or not. Amazing. So the second point, every information will be accessible to everyone. In 1980, when I was at the university, it was important to have information. If you knew the accordion of the court law of Piauí, you know, that's a forgotten state in Brazil, well, this is the guy that was the most important guy. Nowadays, you have information everywhere, and it's going to be more and more. So in some years we will have to we don't know if we will have privacy. Blockchain will be there for guaranteeing, etc. And virtual money, well, we could have maybe virtual money. We just don't have that because, I don't know, there's the privacy thing. But I think information will be accessible to everyone at every moment, everywhere. And the third point, that's a lesson from the pandemic. everything that has a cost will be forgotten. So we started seeing how many things were not useful we could notice at the pandemic. For example, we would use all this quantity of paper in the printer. When we started to do things like by video conference, and this is how we say, no more printing, almost nothing being printed in the office. So it's a cost that will never come back again. Of course, the first consequence is a reduction of litigations, if I may so, because if things can be more predictable, well, I don't have an incentive to fight. Why am I going to fight if I know what the result will be about a contract, for example? So maybe we're going to be able to solve it because you know this more than me. The human being answers to incentives. That's a fact. And now a second thing, when you think information that are not clear, imagine Percy doesn't know if it's going to appear a debit, for example. Imagine if I have a debit. No, it's all clear. It's in the system, in the blockchain. It's all registered. So we don't need that contract with 53 pages anymore because sometimes we know that that's not useful. So I think this is going to disappear. Everything will be automated and available, etc., as I said. Another example, like credits. We had a law for having a different legislation for titles. I don't know. I don't know if I have a debit of 10 million or something. No, is it registered or not? Does it exist or not? So I think this is going to make conflicts change, and the conflicts will be more easily understood by mediation. And I think we could take this 62% of lawyers who are working by themselves and bring them to mediation, maybe, because the lawyer will be essential not only for the administration of a law conflict, but a small conflict of human nature from everyday situation. What's the profile of this lawyer? And this is the third and last point. The profile of this person should be a specialist, somebody with general culture. Until the 70s, the lawyers were more humanistic, people who know a lot about humanities. After the 70s, I think we graduated people who are specialists in the law number 3, paragraph of something number 7,200 something, you know. So this is a different approach, of course. So we want a lawyer with a broader perception, because information is not so relevant as it used to be, because information is available to everyone. And what's important is you have a head that can think, the capacity to understand a problem, the capacity to understand another human being. So the lawyer has to become again a strategist, the person that will be able to help a client to make a strategy for mediation for businesses or for a complex problem they have to solve. And that means the lawyer will have to be a good chess player. Maybe the most important things for the lawyer studies, instead of memorizing the constitution, they have to learn how to play chess, you see? you have to practice mathematics. I don't know, because he has to know how to calculate and to think in all these things together. So if they study music, I think it should also help. Thank you very much.
Se eu pudesse, eu ficava até amanhã te ouvindo.
Well, if I could, I would stay here listening to you until tomorrow. No, don't worry about my questions. I'll be bothering you. The most important thing we are building here is a market that should be more, I don't know, healthy, more useful for the clients of law practice. It passes through this flexibility of looking at these pearls and admire them. And this is part of the artistic education the lawyer should have. So I would come back to Bruce. I would like to come back to Bruce because I remember when I worked as a lawyer in the United States, and I would like to check with Bruce if he could say something more updated because my memories are old. But we are going back to Bruce later on. But Percio had this experience of a lot of negotiations. All the lawyers would love to work with with Percio, and it's very important to have this view of how we choose a lawyer for these battles that are not trials, these big negotiations that happen so that we don't go to trial. Thank you, Luciana, for the invitation. Uh-huh. Bruce, you'll be able to speak later on. Okay, thank you very much. Sorry about that, Bruce. I'm sorry. You're going to speak. Your microphone were muted anyway, but later on it will be your turn. Okay. So it is a pleasure to be here to share the panel with Bruce and José Gabriel. I will separate your question into first. It is important to talk about what is the challenge for the success of a transaction. The lawyers. What I learned is that there is no cake recipe. There is no standard recipe. Bruce talked about this before. I will talk about the poet José Ortega Garcés. The man is the man and its circumstances. If you substitute the man by the negotiation, this is the basis of the negotiation. Negotiation, for you to be able to dominate or have more chances of success, you have to understand circumstances. And I think these are two main challenges: to understand the people you are talking to, second, to understand the context. And the context will be divided in the moment of the people who are talking and the need of the negotiation, the moment, and the need of the environment. So, this platform leads to something that I also learned as time passed, and that means every negotiation has its idiosyncrasies. You have to understand what that idiosyncrasy is. You have to understand what is the motivation for the negotiation so that you can establish the parameters for the approach. I remember One of the first negotiations we made, it was selling the Ipiranga group. They tried to sell that many times, it was not possible. This is a group selling oil and petrol in Brazil. So what was the main problem? We had 4 companies open with shareholders, different shareholders, and the controllers had different participations, and we had 60 controllers to sign so that we could make the sale. So we had to understand this idiosyncrasy to begin with, to develop the structure, the engineering, and the basis of the negotiation. So this platform was an initial phase. After that, we have usual matters of establishing the negotiation that's constructive and not antagonist, and it's when you decide the price and how you establish the money that will be used. So this is fundamental. To have this basis, this understanding of what is the foundation. Well, I'm a civil engineer, so I like to talk about the relationship between physics and engineering, right? So this is a solid foundation so that you have a good negotiation. Now, when you talk to lawyers, what's the profile of the lawyers that we learned and we value? It has to do with what Gabriel mentioned. There is a school for law practice that's very good and solid in the past. Then I think we had this excess of details, and now it's coming back to being broader again. What I learned is that price is only 30% maximum of the negotiation. Most part of the time-consuming efforts and ideas is what we call reps and worms of representations and guarantees, the discussion of the obligations, etc., etc. And that's when lawyers come. And this is not clear to me until now. If this part is so difficult because you have lawyers, or because it have lawyers, is it difficult? Because sometimes I think one thing and sometimes I really think the other. So the lawyers, they're fundamental, of course. You have a profile of lawyers you have to have so that you have more chances of success. And the position of the lawyer may make a negotiation go bad or not. So in these parameters we discussed, and nowadays I think, which are the 3 main elements that are not so common but are important for a lawyer to go to a success negotiation? First, empathy. It seems foolish, but it's fundamental. I always think that when you're having a negotiation, you have to remove the mirror from the negotiators and the lawyers. Imagine you're brushing your teeth, looking at the mirror, start negotiating, the mirror will always agree with you, right? Well, then you get to the negotiation table and the other people is not a mirror of you. Well, so it's the 3rd law of Newton. Every action has a reaction that's the same and contrary. So if you have no empathy, you're going to put things in the contract that are important. And the negotiation may be lost. It may be long, and everybody will be tired. So we always make the exercise with the lawyer. Sometimes the lawyer comes with something complex. Okay, if you were in the other position, on the other position, on the other side, what would you say? It's not nice, but it's important to make this exercise. Second point, creativity, creativity. I think lawyers should look at the wilderness, right? You have to look, if you are in the middle of the trees, for the space between the trees, or you will collide with the trunks, right? So I have to agree with the psychologists, because you have to have a motivation. When you have sometimes, I don't know, sometimes it's interesting to talk about a problem. No, we have to talk about the solutions. It is another good exercise to talk about the solutions, not talk about the problems. And sometimes people miss this point. And the last point I'd like to mention is the capacity of deciding what is a priority. When I started negotiating 20 something years ago, we had 40-page contracts. It was very common. Nowadays, we had 3 negotiations and they had like 75 pages. And there is a lawyer who has been a partner, Luis Leonardo Pentigiano. I don't know if you knew him. A very good lawyer, my friend. When we started these discussions, he would say, I have to protect myself from this or that risk. He would say, there is no way you will always be protected from everything. The only way you get protected is you leave the negotiation, right? So forget about it. I'm not going to cover everything. And also, we had other examples with other big companies in Brazil, like Casas Bahia. It's like you're looking about the cockroaches, and there are elephants in the room. So this is the metaphor. You forget about the cockroaches. You know, you look for the elephants, right? Look for the big things. Look at the whole picture, and then you see the big risks, and these will make a difference. So as a summary, these are the 3 points, 3 aspects I will always be looking at. Now there is a discussion to complement here about negotiation. Oh, sorry, about mediation. When we are talking about mediation, there's a lot of interesting characteristics. Bruce also talked about this. Mediation starts. What's the difference between mediation and negotiation? By definition, they happen after you have a negotiation that failed or a problem after that. So it is very relevant to know how to listen. If you know that you have a mathematics metaphor, you're not going, and he's trying to use a metaphor like the triangles. There is no way the same triangle will be the same as a negotiation. I'm not going to talk about mathematics because this is not the area. But calm down. In mediation, you have to be more calm, even more calm than a negotiation, because the context is important. And I'd like to say something to Bruce, something I heard the other day. I had read about something in the 70s. There was something in the integration in the United States, the integration of colored people in the American society in combination of, racism, etc. There were conflicts. And I saw a movie the other day. I like watching movies a lot, and I recommend this movie. I watched a movie the other day, and it's called The Best of the Enemies. It's at Netflix, The Best of the Enemies or something. And it's about what they call charrettes that were mediations made in the US in North Carolina with the president of Ku Klux Klan and an activist of black people. It's excellent. There was this black guy, he was a mediator, and he was discussing with the president of Ku Klux Klan. I imagine that. So this is what I wanted to say today. Sorry I spoke too much. Okay, one thing that caught my attention is that I believe, well, I've been there in situations that were different, but I've been there. When you are in negotiation, you are external, like you are, your company is faced on that. You need to be a mediator between your client and the reality of the table. you need the lawyer who has a technical view to give you the foundation of consciousness of the reality that's on the table and not what everybody wanted it to be, like looking at the mirror. So this brings a lot about this importance of these tools for mediation. And it's a lot. Now I'd like to come back to Bruce. Unfortunately, we never have enough time. Time flies. But I would like to come back to Bruce, bringing a memory of the time I get to know Jens in 1998, I guess, 1999. I was working in the United States in a law firm, and the law firm I worked with was one of the pioneers to bring cases for the mediation agents. So I had the opportunity at that moment to see how mediations worked, and then I fell in love with mediation. And I thought, oh my God, I had the opportunity to see mediation with Bruce and other mediators who were wonderful too. I felt like a child going to Disneyland, and I would go to Mickey Mouse house. It was the best. So that's my mission of life. But in that moment, and bringing to our market for law practice in Brazil, we are many years behind if we compare with the market to the US, but we are going fast. And what caught my attention by the time is that inside the law offices, there were departments of lawyers focusing on working in mediation and negotiation. It's not that the lawyers were mediators. They were working for the clients, although a good lawyer is probably a professional who is going to be able to understand the needs of the other side, of course, and help to pack the demand of the client so that the other side can receive the package. That's very useful for the work of a mediator. But this lawyer that's a specialist in mediation, Bruce, is that still a tendency in the market of the US? And how do you see this need that you all mentioned and that I will summarize? That's what I heard from you. The need to transform this law aspect. It's not a cost, it's an investment. That's this transformation I'd like you to mention or talk about. Bruce.
You have no mic.
You have to open your mic, Bruce.
Thank you again. I was just saying nice things about you, but I'll have to say them again. The great conversation with my colleagues. I could spend the next hour or two just engaging in dialogue based on things that they've shared with us. Unfortunately, we don't have that time, but I wholeheartedly agree. Not only do mediators, but aspiring mediation advocates need to develop similar skills around the process, those skills of empathy, of creativity, of listening, and so many others that were mentioned. Those are things that the lawyers of tomorrow need to perfect, things that aren't taught in schools. You mentioned you're catching up with the American market. I have taught mediation in 25 countries, and my hope is that by developing and delivering lessons that we've made in our country, many successes, but many failures as well, people can speed up the curve, if you will, and learn from those things, passing it through a filter of culture and language and economy, because our needs are so profound in the broadest sense. But I think you're going to see, to answer your question specifically, more and more law firms developing an expertise in mediation and alternate forms of dispute resolution. I was just doing a training in mediation advocacy last week for a 1,000-member law firm based in San Francisco. And I had as one of my guests to co-teach a fellow that you would know, Gabriela, from China, who was talking about his knowledge of law firms in Beijing and Shanghai who have begun to specialize in mediation practice. And I think one of the things that can differentiate Brazil from other countries in capturing the successes of the mediation economy and marketplace is to recognize that can be largely a client-driven phenomena. Clients are more and more familiar with and sophisticated about the use of mediation. And it's an experiential thing. The more people experience the magic of the process, the better. And so when we go to countries, we put people through role plays. We've done mediation training for banking groups of lawyers in Rwanda. Even in the United States, we did an experimental training about 6 years ago for Stanford University Hospital. And it was the preventative aspect of mediation skills, training doctors and nurses and executives in how to employ mediation skills in the workplace to avoid disputes from taking on the tone of larger disputes that find their way into litigation. And so successful was the program that the Stanford CEO came up to me afterwards and said, you know, in our university hospitals, we have an emergency crash cart when someone has a health emergency. We need to have a similar crash cart for dispute resolution, where trained mediators can arrive on the scene of disputes and help dampen those disputes or otherwise help people find resolution before they take on a life of their own. So this idea that mediation is entirely directed by the judiciary or by statute, while true in some developing countries, in more sophisticated countries like Brazil, the opportunity for clients to drive the business, the opportunity for ombuds jobs within large organizations like we have here in the United States, be they hospitals or high-tech companies, many of which you'd know the names of, or universities. Those are more and more prevalent in this day and age as mediation extends beyond just civil litigation. And I'll say, because it was part of the broader conversation, one of the great things about mediated solutions is they allow people to, yes, take into consideration the facts and the law, but that's only the beginning, not the ending of the negotiation. And so things like social justice and societal considerations find their way into the conversation. Certainly, impact on the environment, more and more important for all of us, finds its way into the conversation. I even wrote a blog within the last 12 months questioning whether mediators after the pandemic should go back to mediating in person based on the environmental impact of those decisions. So mediation is much broader than the commercial environment that we're talking about with lawyers. But I just want to put that out there so people recognize not just the importance of this discussion in the moment, but the importance of this in broader society. Because those issues that impact us and impact your neighbors transcend borders, whether it's climate control or, as we've seen the last few years, pandemics, wage and wealth disparity. We could go on with all those things we read about every day in the paper or online, but those are the things that are going to require the types of skills that lawyers are being trained in today in mediation. And they're going to be issues that we have to address in real time, not waiting for the courts to come around to solutions in 3 or 5, or God forbid, longer years. So I know that's a lot, but I wanted to at least introduce into the conversation that the future of lawyering is intertwined with the future of mediation. And as people learn that, they're going to learn that their clients are going to be driving those decisions as readily as the courts or anyone else. And those mediation advocates who master the process through developing skills like emotional competency, communication, empathy, etc., are going to be the lawyers of the future, those that are sought out in their law firms as they develop specialty practices. But anyway, again, thank you for the rich opportunity to listen to my colleagues and to address those questions.
Bom, sempre dá vontade de fazer mais, mas
We wish we had more time. Unfortunately, we can't. We got a 5-minute bonus in our panel, and we do have a question here that just came from YouTube, and I really need to go ahead and present that question because it's very important for those who are in the market, which José Gabriel gave numbers for. And the question talks about numbers very clearly. And the question is, the solving demands without going to the court is seen as many as a reduction in payments. Is it possible to approach these matters in conflict resolution through mediation? Can that be solved in this environment? Gabriel, I think that is an important question. Bruce, maybe after that you could talk about this payment aspect, honoraries in the United States. And after that, Percio, we only have 3 minutes, okay? I know, needs to be very quick. Now, it is actually very simple. You can make money, and a lot of money, by working in mediation for a very simple reason. If you go to court, the lawyer will sell their time, their knowledge, the qualities. In a court, in a lawsuit, that'll take 5 years, and it'll use the time, the lawyer's time for 5 years. So, if lawyers, instead of going through these 5 years and go through many different mediation processes in that time, then lawyers will have financial, economic results that will be much greater than if they go to trial. That's how simple it is. I believe people haven't looked at it from an economic point of view yet, and it's without a doubt it is possible to be paid more with more opportunities to mediate. That's it in a nutshell. Very efficient answer. Thank you very much. Anderson Adam had asked the question. Bruce, could you maybe give us your perspective how lawyers will make money with mediation, and maybe compare that to making money with to litigation?
Certainly. You will find this as no surprise, but this is a conversation I have in every country that I visit. And lawyers deserve to make money as professionals, and the service they provide is a valuable one. But it all starts with companies understanding the true cost of conflict. So often companies limit their knowledge of conflict to what they pay their outside lawyer. But what we all owe the clients is a better appreciation for how conflict affects their enterprise, how it impacts their morale, their reputation with clients, their reputation with future employees, not just the time they have to spend involved in litigation. And when true entrepreneurs fully appreciate the cost of conflict, then it's an easier transition to paying lawyers appropriately, and mediators, I will add, who can get them out of those conflicts in an efficient, timely manner. And so I do think we need to have a conversation, not just in Brazil, but in other countries, to re-examine the economic model about how lawyers have been reimbursed for services historically, because it may be true that the ancient model of billing hours and selling time is not the appropriate model when we're talking about conflict resolution. And that's a topic and a model discussion for a different day. But it's a valuable service, and I can assure you, I think my company was making $250 million last year mediating disputes, and I assure you there are mediators and lawyers who come to our office who are doing quite well.
É inspirador. Eu queria só ouvir do Pércio.
That is very inspiring. Percio. Now, Percio, have you met lawyers that you actually said, okay, I this one I really want to pay them well, you know? or maybe never met him. Oh yeah, many lawyers have contributed a lot during negotiations, and I believe that payment and compensation goes along with it because mediation is a dispute, but it takes place in a shorter span. I mean, as Gabriel said, and then that requires compatible compensation, and sometimes, time is money. I believe that it certainly can compete with the traditional payments and compensation. Now, the question would be how to hire the lawyer to be a partner in the business and not in the conflict. Yeah, but I believe that this whole movement, such as the one that you expressed in this seminar, creates the awareness because we come from a different premise, a different paradigm. Lawyers used to be the one finding the problems and then find the solutions for them. They weren't really worried about the solutions. They were more concerned with having the problems and issues in the future. I think that's changing, and I think that happened before and earlier in the United States because they have a greater culture of litigation there. But I think that is changing, and we see these movements, and I think it's only a matter of time. Um, Dear panelists, it certainly is a shame to have to finish our panel with when we see so much wisdom here and with all the people who need your wisdom. But I am sure that our next panel will also contribute to that. Will be sensational, and we'll certainly finish tonight and leave here with the desire and the wish to have more and do it again. So thank you again for your great
Thank you.
contributions. Thank you. So we conclude here panel 1, and we will move on to panel 2.
Transição. Quem
Thank you very much.
quiser
My
entrar com a câmera
eternal
pode
gratitude.
fazer agora ao momento.
Thank you. Bye-bye. Enjoy the rest of your.
Ok, vamos entrar com a câmera.
Okay, now
Três,
please next panel cameras on in 3, 2, 1. Good evening to all of you. It is a great joy to be here with you tonight. Also, if you're watching the recorded version later on, we also greet you. I would like to say thanks to all the organizers, especially the tireless Professor Luciana Dremil, who is tireless and really devoted to sharing the wisdom and the kindness. It is a great joy to be here, especially to talk about a topic that is so important. And it has been important for a long time. It is even more important today.
So in panel 2, we are going to talk about the practice of law practice and having good results through mediation and negotiation. I think this panel is based on two axes with the mental map of the lawyer, shared experience. And for that, we can count on our dear Vic. And Vic, I'm sorry if I can't say your name correct. Is that Chester? Is that good enough? Okay. Thank you very much for your kindness. Also Marilena Winter, also Rafael and Marilena. And the CV is very long, and I admire these speakers so much. Some closer and some from further away yet. But I admire Vic because of the open smile and being this man that for 50 years has been a great gardener. And he's a gardener who develops activities in many countries. Especially, he's a founder and president of the Foundation for Initiatives that are sustainable for juridic practices. It's a non-governmental organization. And being a lawyer and mediation for 50 years. I am also a big fan of Mariana Winter because her CV shows by itself the leadership of women. She was the first woman elected as OAB Paraná, doctor in the Federal University of Paraná, main teacher of civil law in PUC Paraná. So she was the first woman elected as a president. And this is our dear Marilena, who has all these qualities and will share with us her experience in OAB, which is the Order of the Lawyers of Brazil, OAB. Mauricio is dear to me, and he's a wonderful person. And this is Mauricio, who lives always traveling from here to there. I don't even know from where to where he's always going and coming, but Mauricio is a special participant in the house. He has 30 years of experience. He's a lawyer in Brazil, in New York. He's a consultant, a mediator, and he has many characteristics. And Mauricio Gon is an excellent writer as well. I hope he can share with us his so many activities in so many universities, and also our dear Rafael Alves, who is part of the institutional, the academy, and the law practice, and he's a person who works with excellence. He's a mediator for complex negotiation. He has a broad CV. He's a director of Civara. He's a doctor in the law by USP, University of New York. Many prizes he has won. And this is our team. This is our team. This is our dream team to talk about this interesting theme. We will start with Victor, who will open saying how to expand the practice of law. See how hard, huh? How to expand the law practice to have good results through negotiation and mediation. With your experience, we could talk about many countries, but I think we are talking, of course, about the US now. So the floor is yours, Vic. You can open your mic and speak.
Okay, can you hear me? Good. Well, thank you so much for the opportunity to participate in this very important conference and with the eminent colleagues that have joined in the conversation, both in the United States and in Brazil. I'm only sorry I couldn't be there personally with you to reconnect with my many friends who I see on this conference, but I hopefully we'll be able to do that in the future. I want to use the time that I have to kind of set the stage for our panel discussion in the minutes that are available to talk about the basic 5 points that I think will be an effective way to open up the dialogue on how to build as a lawyer in a law firm, whether a partner or a skilled associate. How have I found in the United States, as well as seen overseas, that you can not only maintain a profitable practice, but build a profitable practice? And I will tell you on a personal level, a much more emotionally enjoyable practice than all the excitement and pressure of litigation, no matter how competitive you might be. So what I'd like to do is hit these 5 points and hopefully provide the framework for our discussion with follows. 1, how do you build support for an ADR practice within the law firm business? And that begins with understanding the value of an ADR practice. And Bruce has touched upon this, as have others. But it starts with understanding that you're not dealing with just proving who is right and wrong in litigation. The focus of an ADR practice or mediation practice is understanding the mindset that your focus is on how to resolve the client's problem in a positive and a voluntary way, which oftentimes is only related very loosely to the legal rights. Sometimes it's intimately involved, but it's often very loosely related. And it's not who is necessarily legally right or wrong, but it is how do we solve the problem. And in a country like Brazil, where I have worked since, I'm just going back to take a look at it, since 2002, with some of the global mediation work that I've done, I will tell you, with over 80 million cases backlogged in your court system, that is the inability to get resolution is itself a failure to provide a client service. And we had this problem in the United States, and it was through mediation and arbitration to a certain degree as well, that we are able to reach the statistics that Bruce spoke about, that very few percentage of cases ever filed in court ever go to trial today. So understanding this process, how to build support for it by understanding the process, is absolutely critical. There's a very famous poet from the 13th century by the name of Rumi, and it's a quote that we've all used in mediation. And it goes as follows. I hope we can translate this fairly easily. Out beyond ideas of wrongdoing and right doing, there is a field, and I will meet you there. And I think that reflects the heart of what mediation is setting aside for the moment who's right or wrong and putting our hearts and our minds and our open discussion to working towards a resolution. So I think that speaks very much for why it's beneficial to your clients. And as I will talk about a little bit later in the short time I have, it also will be a very profitable practice, as I've learned in the United States. Oftentimes, of course, lawyers are very resistant to do this with their clients. They're fearful of a loss of income from loss of litigation work and trial work. They're comfortable and trained to be very competitive advocates in an adversarial process. So they tend to go there rather than to learn the new skills of active listening, of compassion, extending compassion, of looking how to get beyond impasse and rather focus in on what they're comfortable with. And in many cases, these fears and with the loss of income push lawyers to go back into the adversarial style. And perhaps, as I'll be able to tell you in the question and answer period, I did that in the early days to learn very soberly how important it is to have the right mindset and the special skills of representing your clients in mediation as distinct from trial work, which is a totally different concept. So number one, understand the value of it. Gain genuine, firm support for it and overcome these fears and be adventuresome to try these new skills. Second, how do you structure an ADR practice with the group? I will tell you how I did it in my firm, and I've seen done in many other firms in the United States and elsewhere. What we did is we provided as an additional skill in our litigation group. Some firms have just set up a separate mediation practice or an arbitration practice. We found that to build it as an additional service to our clients, which they came to appreciate as a much more cost-efficient and successful process, was a very successful, if you will, collaboration between these two practices, the litigation, if you needed it, and the mediation and or arbitration, if you wanted to go into alternate dispute resolution. So I'll just mention that that decision-making criteria that needs to be addressed for success. 3, how do you build a quality group of mediation ADR trained lawyers? Well, first you've got to do is really learn what mediation is. And this, of course, conference is an excellent way to enhance that learning. But among law firms generally, in my experience in Brazil, continues to be that many lawyers in large as well as small firms do not understand how mediation is to be used. And they don't understand the distinction between how you advocate in a mediation and how you advocate in a litigation. And if there's time in the Q&A period, perhaps I'll be asked, how did you learn it, Vic? Because I did it all wrong. initially. I went in there and beat up the other side, advocating for my client without an understanding of how destructive that was of my client's interest. And I'll be happy to elaborate on that learning experience if that question is posed to me in the question and answer period. But learning how you go in and advocate for the strength of your client's position, but move towards building credibility with an adversary and a mindset to reach a resolution, that becomes extremely important. And that becomes important in building a quality group, the third element of ADR trained lawyers. Learn how to advocate, learn to be trained on how to advocate effectively in mediation. Also identify who in your firm have the skills, the potential to do what needs to be done in mediation. Not everyone is well situated to do that. There are some people that just go out there fighting, and that's all they know and all they want to know. And there are others who can do both. And in response to a question put to Bruce, I will tell you, you can do both. You can be very effective advocate as a mediator and also be ready to let the fangs hang out and go in there and really aggressively litigate. I did that for the last 25 years of my career. I did both and I loved it. And my clients appreciated that skill and paid equally well for those talents. And then, of course, make sure that you train your partners and your lawyers on what mediation is about and how they can develop these skills to identify who are the best people to train for this purpose. 4, how do you promote business for your mediation or your ADR group internally and externally? 1, educate and cross-sell within the firm. This is not something you just do externally. You, between your corporate department and your employment department and your family department and your property department, have them understand what mediation is so they can bring it into their disputes and not see it as irrelevant to serving their clients and solving their problems. So internal marketing, if you will, and education was very important in this. In our firm, in my former firm, had over 300 lawyers. We had a lot of lawyers, over 100 of which did exclusively litigation. So it was a great marketing platform to bring work into those of us that wanted to do mediation. And then, of course, externally, you want to develop a marketing plan. You want to go out and speak before business groups, chamber of commerce groups, family groups. You want to write articles in this area to build up your reputation. And you want to join professional alternative dispute resolution groups or mediation groups like those that you have, so many good ones in Brazil, so that you can build a profile, successful profile, and people will come to you. Third, you want to learn how to persuade clients on how to use mediation. This is one of the greatest fears of lawyers, to suggest it to clients, at least I have found, initially in the United States and around the world. They're afraid that if they speak about mediation to their clients will feel they've lost confidence in the correctness of their position or have some hesitance to aggressively litigate for them. So there is an art, and I have a whole seminar I've done around the globe, and I do also in the United States, a 3-hour seminar on how you speak to your clients without losing their confidence and provide to them the alternative and encouragement to try mediation without sacrificing their right to litigate if they need to do so. This is an important skill on how to promote your business. And lastly, I will mention to include mediation protocols in your legal documents. If you're doing a merger acquisition agreement, you include a clause which says if there's a dispute with the executive that you're bringing over into the new entity on a part-time basis, or in the terms of the mediation, if there's the merger rather, there's a dispute arising out of compensation and ownership and stock ownership and the rest, you agree, put that in the document, in hiring agreements, when you hire an executive, that you agree that you will resort to mediation as a matter of contract. This encourages parties to use it and find out about its success. And of course, in the alternative, you can provide, if that fails, the parties can go to an adversarial process in arbitration or into litigation. The last subject that I'm going to mention all too lightly is one that's near and dear to all of your hearts that are joining in this conference. And how do you profitably bill for mediation services. And I want to repeat the premise I said before. I, like you, had a fear when I was first asked by the federal courts to participate in mediation training and help the courts bring cases to mediation. What was one of the first things in my more selfish mentality initially thought about? My goodness, if I do this, I'm going to lose litigation fees. And of course, this is an understandable and legitimate concern. I want to assure you that as I built and we built in my firm, and I've seen in other firms, the additional capability to provide quality mediation and arbitration, but essentially mediation services, we bill for it at full billing, hour billing rates. We were able also to use, if you will, fixed rates very profitably. We had clients that were willing to pay us a bonus if we settled the case through mediation without litigation, recognizing that we lost a large amount of potential litigation fees. And I know that you in Brazil have what you call succumbrance fees, which is something like what we have in contingencies. And I've talked to many of you in Brazil about this. You can work in appropriate succumbrance compensation as a resolution in the mediation process without losing the value of mediation. I'll leave this primarily to questions because it's a whole topic unto its own. So given the time limits that have been provided, I hope that these 5 points tee up, if you will, good areas to discuss with my panelists and to motivate your questions in how you can effectively, successfully build a mediation practice. And I'll conclude by saying that if any of you want to talk to me about how you can build it profitably in a way that your firm will not lose overall revenue, but will enhance the revenue and increase your client satisfaction so they will come back to you more and more, feel free to contact me. Thank you very much.
Obrigada, Vicky.
Thank you, Vic. The way you approached the topic was very interesting, based on the 5 points. Seems to me that what they have in common is related to culture. It's the mental map or roadmap, the development of such a map, first of all, for your own activity and actions as a lawyer, and secondly, for your team, your law firm, and then finally towards your client. All of this is supported by education, study, and exchange of experience. You are giving us the opportunity to lead this talk towards Marilena when we talk about mental map and culture. As I had the opportunity in Brazil to participate in many events, the Brazilian Lawyers Association, OAB, for at least 15 years, I have seen this very intense movement towards building a mental map for the private means of conflict resolution. And this could also include arbitration. Marilena, could you please share with us a little bit of your experience and the Brazilian Lawyers Association, OAB, and their perspective, and what you have been doing to foster the private conflict resolution methods and means. Thank you, Fernanda. Thank you very much for the welcome. I would like to greet our colleagues, Mauricio Gum. It's a pleasure seeing you again, even if online. Also, Professor Victor Schachter, I really learned a lot from you. Rafael is also with us, and I begin by saying that our colleague Luciana Tremel created an extremely rich seminar tonight, because many of the talks we heard today, I watched the first panel closely with Bruce, Percio, Jose Gabriel, and others. I mean, those were questions that we hear from many lawyers. Some people are curious and they want to know more because we are part of a culture. We were educated in universities for litigation. And as I just heard from Victor, who spectacularly synthesized the whole topic, expressing great sense in this whole, in the central point of advocating. Now, before I talk about the issue you mentioned, Fernanda, I would like to say that we have reached numbers of 1,300,000 lawyers in the country. So they are hyperbolic in this sense, very large numbers. 80 million lawsuits in 2021. We just heard, actually 2021, 27 new lawsuits brought to the courts. 26 million lawsuits were found resolution in the courts. So we litigate a lot, and litigation times are very long, around 7 to 8 years for a solution in the courts. And I also want to say that in the legal practice, we don't see a lot of familiarity with the topics of resolution through mediation. I believe that the Brazilian Lawyers Association, OAB's goal, um, and I want to talk a little bit about our experience because there are others here more qualified to discuss it, but we have invested in fostering and the prevention of litigation. And I believe that our institution can act as a facilitating environment for practices of avoiding litigation. Now, in our state, Paraná, we were um, the first law school uh, that organized the ESA, and we created the first partnership to educate mediators, train mediators, those who will work in lawsuits. Uh, our school was the first, and I believe that that can be an inspiration for other law schools. Besides, I am personally here, and I had an important contact with Maria Cândido Kretz, and she is a great lawyer. She will join our association and create in our institution the the facilities for lawyers to go and use for mediation. But that would be of no use if we didn't have the specific education for that and training. The school's coordinator, Marilia Xavier, is a lawyer with a mediation background, with deep understanding of the topic. And we also have a coordination for litigation prevention. So I'll try to be objective with my answer. The Brazilian Lawyers Association is able to initially create the environment and become the institution fostering the non-litigation culture in understanding of the present scenario when we are near an unsustainable condition of the judiciary system in Brazil. So considering the exhaustion of the judicial resources in the country, and also keeping in mind that the state themselves is an important litigation party in the country, because all the lawsuits involving the state and the government, they usually take very long, usually twice or 3 times the time. So we have a legal obstacle that hasn't been overcome yet, and the government, the state, is very shy in terms of adhering to litigation prevention practices. And I believe that this is an uncertainty. Now, to bring you a little bit of data, law practice, at least in our state, is very young. 2/3 of our legal practice in our state hasn't been in this career for 10 years. So our profile is of people who are more open to developing the features and the traits that we heard about today, of being lawyers, developing and planning, having the mental map and focus on being a strategist instead of being the protagonist of solutions. They can be the person helping clients find the better results instead of solely aiming at the litigation by itself, as we heard today. So the lawyer will be someone developing the ability to see the whole, to see the system, having a systemic approach, both the ability to feel and put themselves in the other's shoes, as we heard about today, empathy, and based on this, having the ability to support by listening. I need to conclude and repeat what Bruce and Victor said, that the future of the law includes mediation. So for the lawyers that are still building their careers, the Brazilian Lawyers Association has a very important role. Also, the conflicts and disputes have changed, and we are keeping a close watch on the scenario after the pandemic. I believe this was said by José Gabriel, because conflicts are changing in nature, and there is a very important room for mediation. So lawyers in the scenario will be able to help their clients. And depending on our group, I hope that the future of mediation will also continue to require the lawyer's role and education. I believe a lawyer's education converges with our purposes. As Bruce said in the beginning, uh, we need professionals who have a global education and the culture, and can cross through many different areas of knowledge. Maybe as a conclusion of all that, I'd like to say that yes, the Brazilian Lawyers Association, besides all of our institutional roles, can become a source and an environment to motivate the new profile of lawyers and law practice. I believe we need to invest in this as an institution. Thank you, Marilena, very much.
Viajar no tempo, lembrando dos
Um, you remind me of the first events we organized all over the country, talking to lawyers. And in the beginning, we were only a few, and how this audience grew. I had the chance to participate as a member of the Special Mediation Committee of the group in the Federal Council, and I could see the Herculean efforts of the many mediation commissions all over the country to develop and foster in law schools. And in the state of Paraná, the state of Paraná is always an important reference, and especially here, talking to lawyers in Paraná. The Brazilian Lawyers Association is doing excellent work, and we have elected a president talking in the terms as Madalena just did. Okay. Okay, let's try and use the time for some of the questions. And talking about Paraná, we will now hear Mauricio Gom, who's always traveling everywhere. Mauricio, Mauricio, in your whole life, do you realize the differences in these two different roles in your life? Tell us a little bit about that. First of all, good evening to all of you. It is always a great joy having the opportunity to participate in these seminars. I would like to, I agree fully with the words that we heard from the previous speakers, and I would like to thank Luciana Dremel for her, for the organization of this seminar, and in this panel, especially Fernanda Levy, my dear friend, who kindly remembers to mention my mother, who's always present to our events. We brought her to some mediation and arbitration events. She didn't exactly know why, but she was there with us. Now, in the first panel, and when I first received the invitation from Professor Luciana, I mean, we received a script for this event, we received questions, and I was dwelling on the questions and I was trying to figure out a way to answer them. But I need to confess that I made so many notes from the previous talks that were very enlightening and provocative even, that they reminded me of the expression of the Antonio Machado, a Spanish poet, who said that in El Camino, no, hay el camino, so there is no path, the road is made by the walking. So, and that's what we are doing here. I mean, right now, I mean, I am taking the road, I'm walking on this road during this event, but we are all together walking in the new lanes of the extrajudicial conflict resolution. There is no black and white solution. There is no full person on either side. We are all here learning constantly, and that is marvelous. It is good to be humble and have the sensation that we can learn more. As José Gabriel said, even though I have experience in mediation, especially international mediation, my experience focuses more in arbitration. So in arbitration is learning every time. We don't have deja vu ever. That's marvelous because it makes us learn constantly with the resolution, conflict resolution methods outside the court. Now, as Fernanda said, the question was about the role of the judiciary system both in Brazil and abroad. Well, first of all, it is an agreement not to compete. The judiciary system must believe that the methods came to compete with the judiciary system. Now, this statement seems to be unnecessary, but I remember that in the beginning of the arbitration law, and this happened at the end of the last century, and I was talking at the justice court, and the judge approached me after the talk and said, well, in arbitration or mediation, you want to have the shoreline, I mean, the best meat, and it will leave us just the bones. So that was a natural understanding at the time because they fear the unknown, and it's normal to fear what you don't know. Nowadays, fortunately, this idea has been solved and cleared, but it doesn't mean that it's not being applauded or well received everywhere. But it certainly is a path, certainly is a road. Like the poet said, I mean, there is no road. The road is made by the walking. So this clarification is important. Nowadays, we all know, we all hear, I mean, the lawyers, the judges, the prosecutors, and the government, the public administration, we all know about the existence of dispute resolution methods outside the courts. And the speed and the attraction to using them, yeah, of course we have challenges, of course, especially for the government at governmental levels, but they are being solved. So I remember another quote by Arthur Schopenhauer, who said that the truth goes through stages. First, the truth is laughed at. Second, the truth is violently antagonized. And thirdly, the truth is accepted universally as evident. Now, when you propose extrajudicial methods, you propose a paradigm shift. Now, that shift is nowadays a clearly and universally accepted truth. The mission now is how to practice that truth and how to understand it. And as we heard in the previous panel, as well said by the previous speakers, we heard about the role the lawyer's role in all this. Marilena, who I deeply admire because she broke with the tradition. So in this event, it's a certain is a welcome addition to this panel. Because she broke with the old and brought to this panel the natural calling to using these methods responsibly. These methods include the mediation and arbitration. Now, the lawyer nowadays will see an increased span and array of possibilities. And in quotation marks, you can't go ahead and continue in litigation, being in quotation marks traditional. Yes, you can do that. Now, lawyers nowadays also have other roads to follow if they want to. Lawyers in mediation, lawyers in arbitration, or um, as mediators, lawyers as arbitrators. As José Gabriel said, that is no easy task. Bruce talked about the skills and the training, and that was also expressed by Victor. We need to understand very well all the different hats and what is. José Gabriel and mine, the challenge to be a mediator is that as a lawyer, when we hear people talk, I I am, conscious or unconsciously, am mentally processing defense. And that's not what the mediator needs to do. Mediator will hear party A, and they should never be thinking about, yes, if they are right, then I need to see what I'll do. To convince of the different position. That would be a mortal sin. So um, we need to abandon the behavior of a litigation lawyer and put on the hat of a mediator to practice active listening. And even lawyers who are acting as lawyers in the mediation process and also in arbitration processes, their role is not showing the client how aggressive they are, for the mediator, showing their capacity, their brilliance, their understanding. No, the lawyer representing the party in the mediation is different. As Victor said, in mediation, we are not dealing with legal aspects strictly. I mean, who's right or who's wrong. I mean, that is for the judge or for the arbitrator, but it's not the job for the mediator. So, Marilena, I believe that yes, more and more we have an extraordinary increase in this line of work for lawyers, and we are here inside what I usually say, if Article 5 inside third of Brazilian law, if that does not include damage to the right, I mean the law can't do that, but the parties are allowed to take from the judge the monopoly and leave that to a third party as an arbitrator to solve in a situation like mediation. So we are now talking about freedom, and the parties are free to hire, and freedom is not for those who want it. I mean, that would be too easy. Freedom is for those who know how to use it. Now, if you decide to use arbitration, you incorporate a possibility to hand a third party the decision, for example, for the arbitration, and also to a third party the possibility to help me resolve a conflict. So I agree with Bruce and Victor that it is growing more and more important to use with clauses in the contracts, long-term contracts, and also more and more to use mediation in the arbitration processes. Teaching facilities, maybe one of the most reputable institutions in the world in this area, the Queen Mary of the University of London, where I took my master's. They regularly present a survey on different topics of mediation and arbitration, and one of their surveys conducted by the Queen Mary with their practices was what could be improved. You know what they heard? I mean, this is what the users said. They to foster mediation more in the arbitration process. Fernanda, how much time do I have? Is 5 minutes okay? Now, that was the background as to the role of the lawyer. Now I want to talk to the role of the judiciary system. So the role of the lawyer we know. And here we, of course, need to talk about the role of the universities, and we could continue talking about this and also apply the same comments to the universities and law schools. Now, the judiciary has the role to understand, together with the lawyers and the business community, what the traits and the limitations are of arbitration and the other out-of-court conflict resolution methods. And judges should participate in courses and training. That is no sin. We can all learn more, even the judges. In Switzerland, it is very common for judges to participate in mediation, arbitration events as listeners, as audience, to learn, to be able to better decide on matters that get to them. In Brazil, the civil code brought stimulus to all the parties, especially judges who need to foster the use of mediation in arbitration. That is great. But as Confucius said, changing laws is easy. Harder is changing the hearts and minds of men. So we need to have the stimulus, and that will come from all the parts, Brazilian Lawyers Association, the judiciary system, and the arbitration systems. Okay, I believe that now I need to talk about the skills required for tomorrow's lawyers. When my father graduated, all he needed was, going to law school, and he would have a job. You have a law degree? Bingo, we got it. When I graduated in the 80s, I'm not gonna say it was enough too. It would be too simple, but it would be adequate to have a law degree and maybe a specialization. Nowadays, a lawyer needs to have a law degree, specialization, and more masters, PhD, preferably, depending in the field they intend to work in, a foreign language, and understanding the culture.
The world now is globalized, and the client may be across the street or maybe in Singapore or in Sweden. So when you sit at a table for a mediation with somebody from some other country, you have to understand this other culture and you have to understand the difference. Also, this lawyer needs to understand the mess, or they will be less lawyers every day. I remember the words of the lawyer from Rio de Janeiro, Cláudio Vieira de Lima. He would say the lawyer is graduated, deformated, and conformated by what they are taught in school. Nowadays, the lawyer cannot be with a conformity or be deformed. And this is the initiative you can see at PUC. Bruce talked about skills and training, super important, because it's the use of the different hats. I can use a hat as a lawyer, but I can use a hat as a mediator, and I know how hard it is to change the hat. José Gabriel talked about the need to be a specialist. I agree with him. It is necessary to be a specialist as a lawyer, but also you have to have general culture. The lawyer cannot be a person who plays the piano and can only play one note. You go to the table, you have to have general culture. This is a reality. And
que acham que vão ficar famosos.
we have young lawyers, sorry, I need to cough.
Cuidado, muito cuidado com o famoso copy and paste. Copiar e colar, porque está tudo na internet hoje. Está tudo à nossa disposição. O que não está à nossa disposição foi o que foi dito por todos aqui.
So what we don't have is what was said by each and every one here, the creative ability and the instinct to deal with emotions, because lawyers deal with reason and emotions, and the art of practicing the law is the art of persuasion. And I think that artificial intelligence will never, be able to use this hat. Obviously, that is a very interesting topic, and Fernanda talked about it, and I know that I have used too much time, and I don't want to, I want to respect the colleagues that came before me and the colleagues that will speak after me, so I will stop my talk now. Thank you, Mauricio. We have to be careful with time. Now we're going to hear Rafael Alves. And of course, talking about this building the road as we walk, I have had the chance of watching Rafael's career, and I am certain that Rafael is absolutely qualified to talk about this because he has a role in institutional aspects. He worked for many years in private means of dispute resolution in Brazil. He is also active at the university as a professor and as a lawyer. Rafael, we know that law offices, I mean, for a while now, and I believe that this trend is growing stronger to think about maybe a space or a core inside law firms to work on conflict resolution and mediation. Um, some other names, some names are being used as well. I mean, apart from the portfolio that we find on websites and the courses, we know that it's pretty challenging to implement new practices. Rafael Alves. Thank you, Fernanda. It is a great joy to be here with you tonight. Thank you for inviting me. Thank you, Gabriela Assmar and Luciana Dremel, Luciana, a dear colleague. Now, I have spent the last 2 hours taking notes I mean, non-stop. I believe that one of the abilities of the lawyer of the future is active listening. I did that. In the last 2 hours, I learned a lot from the previous speakers. I could also talk about what they said, but I will try to build on what they said. And I believe that Victor did an excellent job of setting the stage, as he said, creating the context and background to develop on. Now, Fernanda, you asked me about practicing mediation and negotiation in friendly methods of dispute resolution. That is a living topic, very much alive. And we founded MAMG 18 months ago. It's pretty recent, actually, even though our practice goes back to a whole decade. The group has been working for over a decade, but it's a new office, and we are uh, an office to prevent the conflict and litigation, especially in civil. And as we were talking, I realized that in the last 18 months, our work in negotiation and mediation came naturally to us. I mean, first you start doing things you don't even realize. You never stop to think about it. But what I do today, I would like to say 25% of my time is dedicated to those methods, including mediation. I mean, we talk about doing mediations weekly. Now, curiously, the market knows us more for arbitration and litigation. But we realize there is a large portion of our work done here that includes consulting, negotiation, establishment of contracts, and mediation. So it is, in fact, a boutique for litigation avoidance. So we do that, in fact. In the last months, I would say that many proposals we received from new clients already had been prepared in proposal. They already had arbitration. And again, naturally, I mean, we never had to stop to try and do things. No, mediation came in the context of what made sense in each case. And I would say that that's more recent in our practice, maybe in the last 3 or 4 months, that is happening more often. And I agree with Mauricio, with what Mauricio said.
Eu também concordo. Eu acho que nós conseguimos passar essa barreira já.
I think we are beyond this barrier. Vic mentioned the course he usually takes for persuade your client to convince the client to do the mediation. I'm interested, in taking this course personally, but I think this point in Brazil, um, I think in Brazil, we are finally passing this barrier. There are others, of course, but you propose mediation, but sometimes you cannot put that into practice. That's another thing. But we are working in that direction, I would think. About the abilities of the lawyer and the law for the future. We're talking about changes, right, in this context of the pandemic. I want to talk about these changes that came to stay. But about these abilities, in the previous panel, we talked about being a specialist or being general, and a certain negative aspect if you consider the specialist, and the importance of being broader as we had in the past. I agree partially with that, but what happens nowadays? We have an exaggeration in some aspects, and it's not so good. For example, I'll give one example in my area. In big firms in Brazil, you have this practice that's a separation of who makes the contracts, who makes the deals, the transactions, as the Americans call it, right? And you make the deal. And the litigation separately. All over the world is more or less separated like that. Of course, this separation is not going to change so fast. Or maybe we just have to cope with that. But there is a reason why these two practices are separated. The fact is that this separation brings to us challenges. Why? Because the lawyer of the litigation is trained to look at risks. When this lawyer comes to a table for mediation, they need to switch, right, the button. Of course, you can do both, like Vic said, you can have both hats. It is possible to be a litigator and, in the same case or in another case, a mediator, a facilitator, of course. Okay? So these are different abilities, but the students, when they come from the university, they are also separated in these cultures. And at the university, you are more taught about litigation and being aggressive. Teach the litigation lawyer is the guy who says no. He says, don't do that, don't do that, don't do that, you have problems, right? But imagine if you go with this head and you only say no, no, no. Oh my God. How can you close a deal with that, right? If you're thinking about a contract is always imperfect by definition. There is no way you cover all risks. There will be no contract. So every lawyer knows that you have to have a way to navigate around risks and share with the client the opinions and get to know the client. And you have to get to know the business of the client for the litigation or the arbitration. You have to understand how the client makes money. So if you are in arbitration, you're more used to it because you want to make a deal. So we have this separation, and my invitation is always for the dialogue. And people have to learn, if they're in arbitration, they have to learn with litigation too, because you have to have good clauses before you have a problem. So sometimes it's not well written, the rules are not clear. when you have more commas and the longer the paragraph, the worse, right? So this ability to write well, I think we have to come back to this posture that's more, I don't know, that's broader, not so specialized. Of course, this division will continue. I don't think this is going to change in the short term, but we have to know how to navigate with more calm. Now I have two more points I'd like to mention. Marilena mentioned about litigation. I have been investing a lot here in the office, in the firm, because it's a previous phase before the negotiation or the mediation. So how do we work as a lawyer so that we can avoid conflict? And there is a whole world we have to learn from the Americans and from the Europeans. They are years ahead of us. I think it's not years, I think it's decades, which is good because we have good examples, right? We can learn with our neighbors. So Brazil still has a lot to learn in this area. So when you're talking about a company, no company wants to spend money on litigation. Unless you have a fund and you invest in litigation, but who will do that? So the companies make money with something else, not with litigation. So if we help avoid litigation, we are putting litigation out of the way, because between your client and his objective, there is litigation. So you have to remove this stone from his path. So Brazil could develop this. This is a very good context for Brazil nowadays, and also all over the world. The context is what Luciana said in the beginning. She started talking about consciousness in capitalism and the context we have in the country because of the financial market that has started working with that 2-3 years ago. And the problem of this discussion is a separation of who is G and who's not. But let's talk about consciousness and capitalism, all the stakeholders. Let's imagine companies want to be more human. Of course, litigation will go to this agenda. It's not yet there. It's not so connected. We are talking about carbon footprints, some other aspects, but nowadays the concern is broader than what's being discussed, and we as lawyers, we work with litigation. Very soon we will be called to participate in this discussion actively. It makes no sense that a company works with consciousness in capitalism, human practices, and when they have litigations, they are aggressive and they have accusations. It doesn't make sense. So if the world will go to that, the resolutions should change. So I want that to be clear. We will always have litigation, of course. We will always have arbitration as well, because sometimes you need somebody deciding. That's it. So what I think will happen in the future is that we'll have more consensus, because a company doesn't win having litigation, they win doing their business. So we have to help our clients fulfill their purposes and not losing time and money with litigation. Rafael, during the event, I was thinking about you listening what we were saying. I love to hear what you had to say. And to bring this coming back to the beginning, this broader point of view, this systemic point of view, experiences, and the lawyer for the future and law in the law practice in the future is here already. Lawyers from the future in the present. Thank you very much. We are late already. We had wonderful questions here at YouTube, and you already answered most of them. I really thank you for the opportunity. Congratulations. Now I pass the floor to Marcos so that we can close. Thank you very much. Microphone, please.
Thank you, Fernanda, and all of you from the Edwards Mediation Academy and Impact Hub. Also would like to thank you all for being here, the audience, the panel members, the translators, people who are in the background contributing and helping our event. And I would like to help us support this organization, Lawyers Association of Brazil, Paraná, the National Federation of Lawyers, meeting the Negociação Americana, Institute for Collaborative Practices, Instituto da Cor. I mean, lots of people in support, GSP, Starter Group. We also invite you to be together again in our second international conference, Future of Advocacy of Law Practice. We're going to have news for you again soon, and we will tell you. Thank you very much to all those who participated. Thank you. Okay, going out in 3, 2, 1.
Maravilha!